This Legal Bite is brought to you by the Dental Services Network, supporting teams in dentistry. Craig, the restraint is in the contract. It's signed by the dentist. It's binding. A common mistake made by dental practitioners. Hello, I'm Dr. Craig Cameron, and this Legal Bite examines the topic, when are your contract restraints binding? So what is a restraint? A restraint is intended to protect the practice owner's interests by restraining a dentist from doing something after the contract ends. The dentist may be restrained in a number of capacities: as a seller under a business sale agreement, as an employee in an employment contract, and as a contractor in what's known typically in dentistry as a facilities and services agreement. There are two common types of restraint: stopping a dentist from being involved in a competing business, and stopping a dentist from approaching or taking away from the dental practice, patients, employees, or service providers. Both restraint types will typically have a time limit known as a time or duration restraint, and in the case of a competing business, an area or geographic restraint. So how do the courts deal with these restraints? Important to note that the court presumes that the restraint is void because it is preventing the dentist from earning a livelihood. The onus then falls on the dental practice owner to prove two things. First, that the dental practice owner had a legitimate business interest in imposing the restraint. And second, the scope of the restraint is no wider than is necessary to protect that interest. So in the case of dentistry, a legitimate business interest includes things like confidential information and trade secrets. For example, a dental practice may have a particular business strategy or a social media strategy that, if in the hands of a competing business, could be used to the detriment of that dental practice owner. The other major legitimate interest is goodwill or patient connection. So a dentist develops a relationship with the patient that is strong and is such that that patient then moves with the dentist once that dentist departs the practice. Now, the initial remedy for an actual threatened breach of the restraint is what's known as an interlocutory injunction. The turnaround time on an interlocutory injunction is very quick. You brief the solicitor will file an application for the injunction, typically with a state Supreme Court, and the matter's heard very quickly. An interlocutory injunction is a temporary blocking of the dentist's ability to be involved in a competing business or take away or approach those various stakeholders of the dental practice, such as employees as well as patients. So what are the key legal bites that you need to know? Number one, restraints in a business sale agreement have the best prospects of success. And there's a simple reason for this. Goodwill is a significant part of the consideration paid by the buyer of the practice. So to enable a seller to set up a competing business or take patients after the sale undermines the goodwill attached to the sale. To improve your prospects of enforcing the restraint, make sure you have cascading restraints in your agreements, but you can't have too many of them. What's a cascading restraint? It's a series of restraints starting from the widest restraint through to the most narrow. This enables a court to strike out those restraints that are seen as too wide, beyond the scope which is necessary to protect the dental practice owner's interests, until the court reaches one which it considers to be reasonable. So for example, a duration restraint might be 6 months, 3 months, 2 months, 1 month after termination of the agreement. Second, limit your competing business restraint to a radius around the practice. So I've seen restraints whereby a dentist is prevented from being involved in a competing business in Queensland. Too wide a geographic area. Keep it to a radius. It might be 10 kilometres, 5 kilometres, 3 kilometres, 1 kilometre. A series of cascading restraints. Third, limit your patient restraint to patients whom the dentist has dealt with in a period of time prior to termination. So the restraints that I've seen put a time limit of 12 months. So the dentist is prevented from approaching or taking away patients with whom they've dealt with in a period of 12 months prior to termination. Also, prepare for the dentist's departure. So prior to their last day, draw the dentist's attention to the restraints. Make it very clear what the restraints are in a diplomatic way so that the dentist is put on notice. This will help you with enforcing the restraint. Second, check the dentist's social media channels. Yes, you can snoop for publicly available information. The dentist might be telling you that they're moving somewhere else, but their social media channel may suggest otherwise. They may be setting up a competing business or joining a competing dental practice close by. As they say, loose lips sink ships, and there are plenty of loose lips on social media. And finally, consider negotiating a separate agreement or deed prior to the dentist's departure. So remember, you have a series of cascading restraints. You can sit down with the dentist and agree on a duration restraint and a geographic restraint. And a separate agreement is more likely to be enforced. And finally, please have a lawyer with dental expertise draft the restraints. At the Dental Services Network, we have a panel of external legal service providers that can provide you with a cost-effective and tailored restraint for your practice. And that's the Legal Bites for this week. For further information, go to the Dental Services Network homepage at www.dentalservicesnetwork.com.au.